Welcome to csstudents.com. New concepts under the Companies Act, 2013. Presentation on one-person company. The Companies Act 2013, or we say New Companies Act, was approved by the Parliament in 2013. Some of the sections of the New Companies Act came into force in September 2013 and majority of sections came into effect from 1 April 2014. Some of the provisions of the old Companies Act 1956 are still applicable. The New Companies Act has introduced some new concepts in India's corporate legal system, which were not part of the erstwhile Companies Act 1956. In this presentation, we would discuss one-person company, which is one of the new concepts introduced under the new Act. We would discuss the origin, rationale and regulatory aspects of one-person company under the new Companies Act. One-person company is absolutely a new concept under Indian corporate legal system. Though this concept is newly introduced in India but in the countries like China, Australia and UK etc., the respective corporate laws provide enabling provisions for forming a one-person company. However, in Indian context, so far, there was no concept of one-person company, and minimum 2 persons are required to form a company. If we see the word company per se, the meaning of company is group of people, coming together for a common purpose. So how can one person form a company? Historically also, when the idea of using companies for business purpose took shape in Western countries, the object was to gather multiple people to do business through a common entity which is separate from its shareholders or beneficiaries. Over the period of time, the system of corporate laws evolved by having private companies, public companies, concept of directors, managers, shareholders, kind of securities etc. The benefits of doing business through corporate structures have been multiple. First is, company is a separate legal entity which is distinct from its owners. Company can do contracts in its own name. It can acquire properties. It can fight a legal case to protect its interest as a person. And the biggest one is limited liability. Limited liability means, although the business is undertaken by natural persons in the form of a company, the liabilities of those individuals shall be limited to the amount of shareholding they have subscribed to, and nothing more than that. The concept of limited liability opened the door for multiple people to buy shares in the companies without having any risk of unlimited liabilities on their personal assets. However, one of the conditions of using corporate structures continued to be of having at least 2 persons who have to come together to do business. However, which eventually prohibited single individual to do business with the benefits of corporate structures. Therefore, if any single individual wanted to do business, he could not do it in the form of corporate. He can do it either in his own name or in the name of a sole proprietary. For example, Mr. X started his business in the name of X Enterprises. In that case, Mr. X shall be the proprietor. However, for all the legal purposes, including tax, sole proprietary is not a separate legal entity. Means, although the business is being carried in the name of X Enterprises, Mr. X is liable for all the dues of X Enterprises, and if there are any unpaid outstanding debts of X Enterprises, Mr. X shall be personally liable, and if required, his personal assets shall be used to pay off those debts. Additionally, if in our example, suppose Mr. X is around 60 years old, and X Enterprises approaches any bank for loans or credit facility, banks would be hesitant to give any long-term loans to X Enterprises. As in case of default of such loan, the recovery is possible only from Mr. X, and if Mr. X dies during the tenure of loan, bank may have to face the difficulty to recover its dues from the properties of X enterprises or Mr. X, which may be subjected to disputes by family members of Mr. X. Means upon the death of its proprietor, any sole proprietary would lose its existence. If X enterprises had been a corporate body instead of a sole proprietary, X enterprises would have been a separate legal entity different from its owner Mr. X. It would have perpetual succession. In that case, if X enterprises approaches the bank would have given long-term loan. As bank knows, even in case Mr. X dies, X enterprises doesn't lose its existence and may pay off its debts out of its properties. However, under the Companies Act 1956, Mr. X alone could not incorporate a company for doing business, as he would need one more person to form a company. The new Companies Act provides that option. Under the new law, an individual can incorporate a company as one-person company. The one-person company shall be a separate legal entity and shall enjoy all the privileges of a judicial artificial person, such as owning property, filing cases, etc. One-person company would limit the liability of its shareholder only up to the capital subscribed. So in our example, if Mr. X wanted to run a business without sharing ownership, he can incorporate X enterprises as one-person company. In that case, X enterprises shall perpetually in existence, and in the event of death of Mr. X, his nominee shall become the shareholder of X enterprises. So it will be easier for businessmen and entrepreneurs to approach banks, financial institutions, for funding, and will also enjoy protection of limited liability in their business, in the form of a separate legal entity. Regulatory framework of one-person companies. Under the new Companies Act, Section 262 defines one-person company as a company which has only one person as a member. So any company which can have only single member or shareholder shall be one-person company. Section 3 of the new Act deals with the incorporation of the companies. Section 3 provides that any company may be formed as one-person company, with one member, for any lawful purpose. One-person company, so formed, shall be a private company. Thus, Section 3 provides the enabling provision, under which single person can form a company, and company so formed shall be a one-person company. Section 3 also provides that, for the purpose of the Companies Act 2013, the one-person company shall be a private limited company. Therefore, under the new Companies Act, all the provisions applicable to private companies shall be applicable to one-person company. Meaning, one-person company will suffix private limited in its name. Additionally, Section 3 also provides that the words one-person company shall be mentioned in brackets below the name of such company, wherever its name is printed, or fixed or engraved. As we discussed, under Section 3, any person can form one-person company. The question comes up whether an artificial person can also form one-person company. The answer is no. The Rule 3 of the Companies Incorporation Rules, 2014, provides that only a natural person, who is an Indian citizen and resident in India, shall be eligible to incorporate a one-person company. Means, a company, or a limited liability partnership, or a cooperative society, cannot form a one-person company. So, any existing company, wanted to use one-person company route, to form a wholly owned subsidiary, cannot do so. Also, that natural person, who is proposing to form one-person company, should be an Indian citizen, and Indian resident. As per explanation to Rule 3, resident in India means a person who has stayed in India for a period of not less than 182 days during the immediately preceding one calendar year. So, if someone wanted to incorporate a one-person company, he needs to check two facts. 1. Whether he is citizen of India, and second, whether he was in India for more than 182 days in the last calendar year. Means foreign nationals are not allowed to form one-person company in India. Also, Indian nationals who are living in foreign countries are not allowed to form one-person company. The next characteristic of the one-person company is a mandatory or compulsory nomination. First, to understand the concept and background. Under Section 109A of the Companies Act, 1956, any shareholder or debenture holder of a company can nominate some other person as his nominee. And, in the event of the death of such shareholder or debenture holder, his nominee would be taken as shareholder or debenture holder in the books of the company, in place of the deceased. So, the concept of nomination is not new, with the perspective of the company law. Under law, shareholders and debenture holders are having right to nominate a person of their choice as their nominee. But under law, there is no obligation to nominate. If any shareholder or debenture holder does not want to nominate, law doesn't put any obligation. If any shareholder or debenture holder does not nominate anyone with respect to his holding, in the event of his death, his holding shall be transmitted to his legal heir. Hence, we can say that, in case of normal companies, for any shareholder or debenture holder, nomination is optional and not compulsory. But with respect to one-person companies, nomination is compulsory. Means, any person, either incorporating or acquiring the shares of one-person company, will have to nominate someone. So, the proviso to Section 3 of the Companies Act 2013 provides that the memorandum of one-person company shall indicate the name of some other person, who, in case of two events, shall become the member of that one-person company. And those two events are: first, the death of the subscriber of the one-person company. Second, in case the subscriber of one-person company becomes incapable to contract. For example, if subscriber dies, or is declared as of unsound mind by any court, and loses his capacity to contract, his nominee shall become the member. Therefore, as a mandatory requirement, at the time of incorporation, subscriber of one-person company will have to indicate the name of his nominee in the memorandum. Before putting nominee's name, subscriber will have to take nominee's written consent. Rules provide that written consent shall be taken in Form INC3. Form INC2 shall be filed with incorporation application as intimation of nomination, along with the consent taken in Form INC3. The sole member of one-person company may any time change his nominee. As per Sub-Rule 5 of the Rule 4 of Incorporation Rules, the subscriber or member of a one-person company may change his nominee by intimating to the company in writing. This change could be for any reason, including the death of the nominee or nominee's incapacity to contract. For changing the nominee, subscriber or member will have to again submit the consent taken from new nominee in Form INC3. As we discussed, the subscriber is free to change his nominee anytime. Similarly, the nominee is also free to withdraw his nomination anytime. For withdrawing the nomination, the existing nominee will have to give a written notice to the sole member of one-person company, with respect of whom he was appointed as nominee. So the question is, if the nominee withdraws his nomination, whether the company shall be without a nominee on record? The answer is no. Nominee must be there. Therefore, an obligation has been put on the sole member of the one-person company to nominate another person within 15 days from the receipt of withdrawal notice from existing nominee. So in case of withdrawal, the sole member shall submit with the company the withdrawal notice received from existing nominee, and also the written consent taken from new nominee. Again, the consent shall be taken in Form INC3. Now we know that, either at the time of incorporation, or due to subsequent change in nomination, the sole subscriber, or member will have to intimate the company about the new nominee, along with the consent taken from new nominee in Form INC3. We also know that nominee's written consent given at the time of incorporation was required to be filed with the Registrar of Companies and became public record. Similarly, if there is a change in nominee subsequently to incorporation, either due to change in nominee by the sole member, or due to the withdrawal by existing nominee, the sole member shall make the intimation to the company about that change. And the one-person company will have to file a notice in Form INC4 with the registrar, within 30 days from the date of receipt of change in nomination, along with the consent of new nominee, received from the sole member. So, as per the process of change in nominee, new nominee will give consent in Form INC3 to the sole member. The sole member, along with the consent received from nominee, will intimate the change in nominee to one-person company in writing. And one-person company will file Form INC4 with the registrar within 30 days of receipt of such intimation from sole member. The concept of compulsory nomination in case of one-person company is very important. As any company, including one-person company, is a judicial artificial person, it is must to be known that who are the members of such company. However, in case of other type of companies, there is a flexibility, as there are always two or more members. So in the event of the death of one of the member, other member is available at least. But for one-person companies, there is no other member. Therefore, the law has created the mandatory provision of nomination. Because of this provision, people dealing with the company will know in advance that, in the event of death, or inability to contract, of the sole member, the nominee shall become the member, and operations of that one-person company would continue. In the same way, if nominee becomes the sole member, he will have to nominate someone else as his nominee. To understand better, in our earlier example, if Mr. X incorporates X Enterprises as one-person company, and becomes the sole member, he will have to nominate someone as his nominee. So, he nominates his wife, Mrs. X, as his nominee, with regard to his holding in X Enterprises. In the event of death of Mr. X, Mrs. X will become the sole member of X Enterprises. In that case, as per the sub-rule of Rule 4, within 15 days of becoming member, Mrs. X will have to nominate another person as her nominee, who, in the event of death, or incapacity to contract of Mrs. X, will become the member of one-person company. For nominating that person, Mrs. X will have to take and submit the consent of such nominee in Form INC3. Upon receipt of such intimation, the company will have to file Form INC4 with Registrar of Companies. Other requirements with regard to nomination are: nominee should be a natural person, and is also an Indian citizen residing in India. means sole member of one-person company cannot nominate anyone who is either a non-resident or non-resident Indian. This was all about the nomination. Now, the next discussion is, how many one-person companies a natural person can open. As per sub-rule 2 of Rule 4 of Companies Incorporation Rules, a natural person can only become member in a single one-person company. Means, if Mr. X incorporates X Enterprises as one-person company, he cannot incorporate or become member in any other one-person company. The reason of this restriction is to prevent individuals to create structure of multiple companies for any unscrupulous business dealings. Only. Similarly, restrictions have been put for nominees also. Only a natural person can become nominee, and he can become nominee with respect to a single one-person company. Means in our example, if Mrs. X was nominated by Mr. X with respect to X Enterprises, then Mrs. X cannot be nominated for any other one-person company. The question is whether Mrs. X, while she has been nominated with regard to X Enterprises, can form her own one-person company. Say, for example, Mrs. X wanted to have her own ABC Enterprises as one-person company. The answer is yes, she can become the member of another one-person company, while she is acting as nominee in X Enterprises. Means one membership, together with one nomination, are allowed for each natural person. But two nominations and two memberships are not allowed. An individual who is already a member in a one-person company may be nominated with regard to another one-person company, but not in two. But what happens if Mr. X dies, and Mrs. X becomes member in X Enterprises also? Then, in that case, she will be the member in two one-person companies simultaneously. First, X Enterprises, for which she was initially a nominee, and due to the death of Mr. X, became member. The second is ABC Enterprises, which was formed by herself. Sub-Rule 3 of Rule 4 of the Incorporation Rules deals with these situations. Sub-Rule 3 says, where a natural person, being a member in one-person company, becomes a member in another such company by virtue of he being a nominee, such person shall meet the eligibility criteria within 180 days. Means within 180 days, Mrs. X will have to choose either X Enterprises or ABC Enterprises, for which she wanted to continue to be a member. Membership of one of the company will have to be transferred to some other natural person. Other conditions with regard to one-person company. Minor cannot become either a member or a nominee with regard to one-person company. Any one-person company cannot be converted into Section 8 companies. Section 8 deals with the non-profit organization registered as company. One-person company cannot carry any non-banking financial investment activities, including investment in securities of any body corporate. Means you cannot create a one-person company for making investments. This is strictly prohibited. Any one-person company can convert itself into a normal private limited company or public company with more members. For example, if Mr. X and Mrs. X wanted to become members in X Enterprises at the same time, it's very much possible, and the conditions are: 2 years have expired from the date of incorporation of one-person company. Either the paid-up share capital is increased beyond 50 lakh rupees, or company's average annual turnover during the relevant period exceeds 2 crore rupees. Means, one-person companies with smaller base of share capital or turnover are not allowed to be converted into other type of companies. Mandatory conversion. Under Rule 6 of the Incorporation Rules, a one-person company will have to mandatorily convert itself into a normal private limited or a public limited company if the paid-up share capital of such one-person company exceeds 50 lakh rupees, or its average annual turnover during last 3 years exceeds 2 crore rupees. If the above conditions are breached within 6 months of such breach, such one-person company will have to convert itself into a normal private limited or public limited company, and accordingly increase number of its directors and members, and amend its memorandum and articles. One-person company, within 60 days of the day when the paid-up capital exceeds 50 lakh rupees, or its average annual turnover exceeds 2 crore rupees, will have to intimate the Registrar of Companies. Such intimation shall be made in Form INC 5. Any existing private company, where paid-up capital does not exceed 50 lakhs, or average turnover in last 3 years is less than 2 crores, can convert itself into a one-person company, subject to approval of its members and creditors. Certain other provisions which are differently applicable in case of one-person company. One-person company may have only one director. Although it can voluntarily have more directors, but law is complied if one director is there. In case one-person company is having only one director, such company will not need to hold any board meeting, and all the decisions shall be taken in form of written resolution. One-person company is not required to hold any annual general meeting. As per Section 122, instead of holding a meeting, member of the one-person company will communicate the relevant resolution to the one-person company for the purpose of recording approval. As a process, such resolution shall be recorded in the minute book directly, and minute book shall be signed and dated by the member as evidence of the approval. Similar process shall be followed for resolutions where directors' approval are required. Annual return of one-person company can be signed either by its director or company secretary. Annual financial statements can be signed by one director only. Thank you for watching the presentation. For more learning materials, please visit www.csstudents.com.